Hello, everyone, and welcome back to Immigration and Jobs Talk Show. Before I move ahead, I would like to read out this very important disclaimer, as always. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, now after this very important disclaimer, welcome back, everyone. You're watching Immigration and Jobs Talk Show. I am your host, Rajni Bharara, and today's episode is going to be a really special and exciting one. And I'm again thrilled to have you all join us for a very special session. Ask an attorney. Yes, it is going to be all about work visa, H1B and L1. This is your chance to ask anything you want to ask related to H1B and L1 visa processes, whether you're navigating employment sponsorship, understanding eligibility criteria, or seeking updates on recent policy changes. This episode is tailored to address all your queries. Now, joining us once again is our esteemed attorney, Sonal Sharma, an expert in immigration law with an extensive experience in the H1B and L1 visas. Sonal is here to provide clarity and expert advice on every aspect of the H1B and L1 journey. So now, without any further ado, Sonal, once again, welcome back. It's good to have you back after, I think, 2 weeks.
Yeah, thanks, Rajni. Good to be back.
Good to have you. And to our lovely audience, I would like to tell you that we are live on YouTube, LinkedIn, Facebook, and also, okay, I think that's it. YouTube, Facebook, and LinkedIn. And the handle is Immigration Talk Show. So don't forget to subscribe to us. And if you have any queries from Sonal that you would like to know about related to H1B visa or L1 visas, you're more than welcome to drop them in the comments. Keep asking your questions because this session is especially about asking questions. It is an ask me anything session. So anything that you would like to know about H1B or L1 visa, go ahead and drop them in the comments below. And now, Sonal. So, Sonal, I'm sure we are going to get a lot of questions from our viewers. But before I jump into that, I would like to come to you. I mean, everyone knows that H1B and L1 is work visas, right? Our work visas. But can you explain, for the ones who don't know, can you explain the difference between these two work visas? How are these two visas different from one another? Let's just start with the difference and then we'll move into the chat questions from the viewers.
Oh, sure. So H1B is, again, both are work visas, but very different. H1B is a work visa which is available for any specialty occupation. Now, what is a specialty occupation? In simple terms, any occupation, there is a list that Department of Labor has of occupations, and any occupation listed there which has an entry requirement of at least a bachelor's degree can qualify as a specialty occupation. There are other criterias as well. As of now, there are 4 criterias. So, but the main basic criteria is that if entry requirement to the profession or occupation, for that matter, is a bachelor's degree, then that occupation can qualify as a specialty occupation. And any employer who wishes to hire somebody on H1B can sponsor them if the job and the occupation is specialty occupation. So like a software developer or a doctor or lawyer, these all can qualify as a specialty occupation because entry requirement is bachelor's degree at least. Now, L1 visas are intra-company transfers. So these visas are basically for multinational organizations which are, established in different countries, and they would want to move their employees from one entity to the another. But there are only 2 kinds available in L visas. One is L1A, which is managerial. It could be a people's manager or a functional manager, or L1B, which is specialized knowledge or advanced knowledge. So when you have a manager in, say, in India, a company has office in India, in Canada, in UK, in US, and you want somebody from UK office or India office, the manager, to come to US and manage a team, a function, then they can be transferred to US under that category. Or if you want to bring somebody who has a specialized knowledge in your products or services or processes, then you can bring that person in L1B category. Now the difference is that there is no cap or quota numbers for L visas in year, but like for H1B, there is like a cap every year, 85,000. There is no such number for L visas, but also L visas are very limited to a certain kind of positions and roles. And hence that's the major difference, but we can get into more detail if needed, but that's the basic difference between two types of visas.
Okay, all right. Thank you so much for answering the question, Sonal, and thank you for taking that up. Okay, for the ones who have applied, I'm sure we are going to get a lot of questions from the ones who have applied for H1B visa this year because they are still expecting the second round of the lottery. So I'm sure we are going to get a lot of questions about that. But who have applied for L1 visa or want to apply, is there something that they should be particularly taking care of in terms of applying for L1 visa?
Well, there are specific requirements if you want to qualify for L1 visa. The one of them is qualifying relationship between the entities. So there has to be a certain relationship between both the entities from where you are coming and to the entity you are coming. And those relationships basically are either the companies need to have a parent subsidiary relationship or an affiliate relationship. Parent subsidiary relationship is very straightforward, where one entity owns the other. The entity that owns becomes the parent entity, and the entity it owns becomes the subsidiary. Affiliate is where a same set of people owns both the companies in this approximately similar percentage. So it could be just one person owning two companies 100%, then the both companies become affiliate because they're owned by the same person. Or it could be owned by multiple people, but as long as it is owned in the same approximate percentage, then affiliate relationship can be established. That's one part of it. And the second part is qualifying employment, that if you want to qualify for L1, you need to have spent at least 1 year in the last 3 years before filing the petition with the company overseas in that particular capacity. Now, if it is an L1A, then you have to be in that capacity for at least a year in the last 3 years on the date you're filing the petition. Or if you are coming under specialized knowledge, then you have to be in that position for at least a year out of last 3 years on the date of filing. So those are the two main requirements: qualifying employment and qualifying relationship. But also there is a very detailed evidence required to show, because you have to see there is no cap here. You can transfer somebody any time of the year. You don't have to wait for the October 1. You don't have to do any registrations. So there is a lot more scrutiny on L1 cases, and that's why a lot of documentation is required from companies' financials, both companies' financials, employees' roles documentation, and all of that. So it's a very, very extensive petition compared to H1B.
A lot of questions from the viewers as well. Okay, okay, Masoom is here, Shiron is here, Mag is here, and then Dharmesh is also here. So hi everyone, I hope you're doing well. And they've already started, sending their questions. So now, without any further ado, I won't take time asking my, I won't take up time asking my question. I would directly like to jump into the audience's one. So let's quickly take our first question from the viewer. So, okay, Dharmesh's question. So Dharmesh says, my H1B visa is valid until 30th September. However, petition is valid until 2027 Jan. I need to go to India urgently. Will stamping be required even if I come back to the USA by the end of August?
No, not necessarily. The visa is valid until September. As long as you come back before the visa is expiring, you will be able to enter the US, and then you won't have the stamping beyond September 30th. Whenever next time you travel, you will have to get the stamping done, though your I-94 will reflect your entry date and your stay until January of 2027 when you enter in August. And next time, whenever you travel before or after Jan 2027, you have to get the visa. But you don't necessarily need a new visa because the one you currently have is already valid.
All right. So congratulations, Dharmesh. There's nothing to worry about. So I hope you have got the answer. If you have another follow-up, let us know. And meanwhile, let's take Masoom's questions. She has actually sent two questions. So let's take it one by one. First question, what she wants to know about is what happens if someone overstayed their 60 days grace period of H1B and then file a transfer for H1B transfer to a new employer on the 70th day.
Well, it will be approved as a consular processing, so you will have to just step out. If you already have a visa, you can use that visa with the new I-797 approval and come back in. If you do not have a visa, then you will have to go get the stamping done and come back in.
Right. Okay. And her
And
second
I am
question.
just to clarify, and I am assuming in that question that this fact was disclosed in the filing. So when you're filing a petition, if it was disclosed that yes, the 60-day grace period was ended on so and so date, and it is being filed beyond that 60-day grace period, then it will be approved as a consular processing. Now, if you do not disclose that to USCIS, there is a chance that it will be approved with an I-94, and most of the people will be, they will be urged to just say, oh, now I have I-94, it's fine for me to stay here. I would request and suggest do not rely on that I-94 because later on in your journey, if these facts come out that you were out of status during that period, then it can have repercussions for your status. So it's always better to not misrepresent and provide clear picture when you're filing a petition, so that you can have your immigration history clean and straightforward.
Okay. Okay. Thank you so much for clarifying that, Sonal. And our second question is when does the grace period starts? End of project or last paycheck date?
Well, it depends. Like, what do you mean end of project? If you are at a client, then the project ended, and if you are your employer is still paying and you're employed with your employer, they are paying you, you're not on bench, then your employment is continuing. And then when you're assigned to a new project, you can go work. But if your employer is saying this is, if the last date of your when the project is ending is also your last day of work, then that's going to be your day when the grace period starts. Now, it's kind of a gray area because sometimes say your last date of work was 10th June, but your paycheck cycle is 1 June to June 15th, then I'm just trying to assume here that he means that can I take the 60-day grace period from June 15th? Well, you technically could, but I don't recommend that. If as of June 11th, you did not have access to the systems, like you could not work, you could not log into your company systems, then technically you are not employed and you were let go as of that date. Then even though that pay cycle is there and you're only paid until 10th, then I would suggest take a conservative approach and use 10th as the last day of work.
Okay, all right. So I hope Masoom, that must have clarified and cleared your confusion. So thank you so much for your question, and I hope you've got the answer. If you have still another question that you would like to know an answer to, please let us know. Drop your question in the comments. We are here for another 40 minutes. So please keep asking your questions. And meanwhile, let's take Shiron's question. So Shiron is also here and wants to know if someone does not want to get stuck on H1B visa, waiting forever for green card on EB2 or EB3, but still want to get their US citizenship at any cost, then what is the way? That's an
Well,
interesting one, right?
well, there you can always build your profile for an EB1A, and if you're not from India or China, the the wait for EB2 and EB3 is not that bad. It's not forever. It's only for people from India, and China is forever. So, but yeah, you can always build your profile for EB1A category, and if you qualify, you can get green card sooner. There are also investment opportunities. You can invest in an EB5 and then get your green card. If you are not from India, you know, then you could qualify for an E2. It's non-immigrant, but there are ways for it to convert into an employment based and like take it from there. Or if you get married to a U.S. citizen or a green card holder, if your significant other has those uh, nationalities where you could use their chargeability, that could be another way. So there are many ways, but it's a very open-ended question. It all depends on what your profile is, what you can
Right,
do,
of course.
what options are there which are suitable for your situation and circumstances, and you probably might find something where you don't have to wait forever for green card under EB2 or EB3.
Yeah, and I think, until the election happens, I think, Sonal, people are really wanting to sort their immigration problem out, and maybe get their visas or whatever that they are trying to achieve. Because post the election, we don't know who might come to power, and then what rules might change. Right? Do you think?
Yeah, yeah, it always impacts. Administration change can impact things. So
But
you can't really plan too much in advance
yeah,
because
of
you don't
course.
know what's going to happen. But yeah, things change and it has been changing forever. So that's the, I think, only constant. Change is the only constant.
Of course, but do you think at this point of time immigrants are really in a panic mode because of the elections? Because only few months are left for the elections to happen, right?
Not
So do you think?
necessarily, not
Okay,
necessarily. We'll see when the results come out and how it goes from there. But it is what it is. It happens every 4 years. So
right, of course. All right, thank you so much, Shiron. I hope you have got the answer. And let's quickly take another question. The next question that is from Meg, and Meg says, employer A filed H1B under change of status and received an RFE to provide additional documents. My employer hasn't responded to the RFE yet, and I received an update from USCIS that my H1B petition is approved. Does USCIS approve H1B even before answering RFE?
they should not. Then there is something very weird going on here. Um, uh, I don't see why they would approve it if they have asked more questions. Maybe check the status again. You may have put a wrong receipt number and got somebody else's status. But if it is a mistake, they will realize it and they can reopen it. So, but no, if they have asked for RFE, they generally, I have not seen them approving it, unless like it was the RFE itself was a mistake. But if there is something that they were questioning in the RFE, then it's very unlikely that they will just approve it without an answer to the RFE.
Of course, it's like the teacher is asking you to appear for your exam. After you have, I mean, not entirely failed, but not passed the exam properly. So they are asking for you to appear for the exams again, and then suddenly they've decided to pass you. So that doesn't make sense, right? So, all right. Thank you so much, Meg, for your question. If you have another follow up, let us know. Meanwhile, let's quickly take Ravi's question. So, Ravi is also here and wants to know, I successfully obtained H1B visa now. What are my rights and obligations as a non immigrant worker in the US, and how can I balance my duty to my employer with my own career goals and aspirations without jeopardizing my legal status or future immigration prospects?
Well, it depends what your goals and aspirations are. They could clearly align with your employment if you have the employment that supports and gives you opportunities for whatever goals and aspirations you have for your career, then you're fine. But if you want to seek different opportunities, then it depends what kind of opportunities you're looking at. Like basically, you just have to make sure that you're maintaining your status. You're not doing anything which is not allowed on your H-1B visa. Your H-1B visa is tied with an employer, and that's your work authorization to work with that employer. Yes, you could do volunteer work, you could, attend conferences and all the like, if that helps in boosting your career. You can write blogs, you can write articles, all of you that you can do that helps your career, but you cannot just like go and start a side hustle working with another employer without work authorization. So, but you can do it. You can also have a concurrent H-1B. So there are ways of doing it correctly and legally. So you just have to be careful that whatever you are doing to achieve your goals and aspirations in career perspectives, then just do it legally and the right way. Have a consultation with an immigration attorney and run your ideas by them and just get the proper guidance what is required to be done. But yeah, as long as you are doing that, you should be fine. It's restrictive in some ways, H-1B visa, because it's tied to a particular employer, but in the end there are ways of, you're not a slave. In the end, there are ways of achieving whatever you want to achieve. You just have to do the right way.
Right. And also, Sonal, you also mentioned that you should not be doing something that is not allowed. So, can you like give few examples that are like a no after you obtain a H-1B visa and you have started working?
Well, it's first of all, you cannot work for any other employer without additional proper work authorization. That's a big one. You cannot. Uh, so people come here like, oh, I'm allowed to work. Like, what about I take like a part-time job? No, you
Yeah,
cannot
yeah.
take a part-time job. You cannot take a freelance. Oh, there's this 2-month contract that I can do on the side. No, you cannot. Oh, can I drive Uber on the weekends? No, you cannot. So all of this related to work, you specifically you cannot do, right? Also, but then people think, can I do a business? Like business in the sense, can I do day trading? No, you cannot. You can invest in stocks, but you cannot do day trading. People buy apartments, that's fine. You can rent them out, that's also fine, but you cannot manage your property on a day-to-day basis. You need to hire a management company. So anything it seems like that, oh no, but those are my property investments. What's the problem in me managing them? No, because then you are involved in the day-to-day running of your business per se, of the rental business that you are. So that's not allowed because you don't have work authorization to do that. So you just have to think from that perspective that you're not doing anything which is not allowed. H-1B is a work visa. You are here to work for a company. You are allowed to do that. Anything beyond that, you just have to be very careful. Now, can you pursue hobbies? Of course you can pursue hobbies, right? If you want to, you are into sports and you play hobby sports, sure, you can do that. If you are, artist and you draw, yes, you can do that. You cannot monetize it. You want to write a book, you can write a book, but you cannot monetize it, you cannot sell it for money. So all those things are there could be anything. You just have to make sure that it is not crossing that limit where it is monetizing and you're getting an income, unless it is a passive income. So just be careful about those things.
Okay. So, any financial gains are is
Beyond your work authorization is not allowed unless it is passive.
okay.
Like your 401k, if you're putting in your 401k money, that's passive income because you've just put it in 401k and it's being, it's in the market and it's getting, investment returns. That's okay. You can invest in stocks also and keep it and they appreciate. You can buy property and it appreciates, but you cannot make a business out of it. So that's why there is a difference in like investing in stocks and 401k and ETFs and index funds and versus trying to do day trading where you are making trades like every hour or half an hour and like doing that work, but then that becomes like a proper job which you're not allowed to do.
All right. Thank you so much for answering the question, Sonal. And Ravi, I hope you have got your answer. Thank you so much for your question. That was an important one. And let us know if you have another follow up. Masoom is also here saying, thank you for your clarification. Thank you so much, Masoom, for your question. Himanshu is also here. And Himanshu says, as a consultant, I see the bigger picture. The US is losing talent and competitiveness due to the outdated immigration policies. How can you justify the rigid requirements and caps on H1B visas?
Okay, that's it. That's the question. Well, nobody is in a position to justify. Okay, when the US economy desperately needs skilled workers to drive innovation and growth, shouldn't we be prioritizing talent attraction and retention over? Yeah, yeah, of course. Everybody agrees on that, that there is a labor shortage and um, US needs skilled workers. So nobody's, I don't think anybody disagrees with that. But in the end, it's the job of the Congress, and they have to make sure that the immigration reforms are done to keep up with the recent times. And until that happens, you are dealing with the system that is outdated, and you don't have any choice but to deal with it.
Thank you so much for answering the question, Sonal. And yeah, somehow I couldn't take the full, I don't know why, but thank you so much for that. And Himanshu, I hope you have got your answer and let us know if you have another follow up. Meanwhile, let's take Uma's question. Uma Neha. Uma says, how is it like rejoining Kforce on H1B visa? Are they reliable with green card process and job security? What should be considered when negotiating the contract with them?
I don't know who Kforce is.
Yeah,
I
exactly.
can't say.
I thought maybe it is a band like
Yeah,
BTS or
I don't
something.
know. I don't know what
If you
Kforce
can
is.
please let us
Sorry,
know,
I
Uma,
have
what
no
K
idea.
Force is.
She's probably talking about the employer who has filed her green card or H1B. I don't know anything about them.
Yeah, but it did sound like that. Thank you so much, Uma. Please clarify what K Force is so that Sonal can give you a better answer. And Raul is also here and says, my H1B visa was picked this year through a consultancy. Since I didn't have a job, I asked my employer to put it in consular processing, which they did. Now I am planning to pursue further studies. Okay. Do we have a second part? Yes, we do. And he says, I have already completed my master's here and I'm currently on initial OPT. How can I withdraw my petition for consular processing before its approval? Is this possible? And what are the steps I can take to stop consular processing?
Okay. Uh, I w- does he want to stop counselor processing, or does he want to withdraw the petition altogether? I'm not sure what he means. But
I think he wants to know how can I withdraw my petition for consular processing before its approval?
yes, he withdraw my petition for counselor processing means you want now change of status, or you just want to withdraw the petition? Well, I see a lot of problems with this question.
Okay.
One is, if you did not have a job, then that petition should not have been filed, because it is a speculative filing. You're not The employer is not supposed to file a speculative filing. You are only supposed to file H1B petition for a particular job that you have now. Uh, Counselor processing only means that you don't want to change your status and you want to go out and get the visa stamped and come back in. But that does not change the fact that the petition cannot be speculative. Like it has to be a non-speculative, genuine petition. So I see as a big problem here, that if he didn't have a job, then the petition should not have been filed in the first place. But I'm not understanding what he means, that now he wants to pursue his studies, but then he has already completed his master's, but
Masters,
then
yeah.
he fail OPTs and withdraw. I'm not able to understand
So,
what he's
Raul,
trying
if
to
you
do.
can please again
If
clarify your question. what you exactly mean by whether you want to withdraw your consular processing, as Sonal is saying, or whether you want change of status. So please let us know what you mean by this. Meanwhile, let's quickly take Karan's question. And Karan wants to know, can my dependents work or study in the US while I am on an L1 visa? And what are the necessary steps to obtain the appropriate authorization for them?
So your spouse can work. I don't know, when you say dependents, there is only one dependent that can work, and that's spouse. Kids cannot work. So yes, the spouse can work on L2 visa, which is the dependent visa for L1A, and you don't need to do anything. It's just incidental to the status. So when you enter US on an L2 visa, your I-94 will reflect L2S, which means L2 spouse. And that is good enough for you to show to any employer for I-9 purposes. That serves as your work authorization. So you don't have to file for any AD, you don't have to do any paperwork. If you have an I-797 with the L2 extension, that can also work. If you entered on a visa, then your I-94 can work. It's pretty straightforward.
Okay, all right. Thank you so much again, Karan, for your question. And let us know if you have another follow up. Raul is actually back and he says that's correct. Withdraw consular processing as I'm not comfortable with the current employer.
That's correct. Withdraw consular processing as I'm not. So you want, again, you want to withdraw the whole case petition. You don't want to go ahead with the H1B filing with the employer. If that is the case, you cannot do anything about it. It is employer's petition and employer has to withdraw it. You cannot withdraw it on your own. So that's what I'm assuming he means. If he's not comfortable with the current employer, it means that he does not want his H1B to be filed. But it is the employer who has to withdraw it. And the second part is that it is filed as consular processing, so it does not impact his status. It is not going to get active, even if it is approved. It is not going to get activated until either they file a change of status, another application, or he goes out and get the H1B stamping on that H1B visa, H1B I-797. So it really does not matter to him, but the employer can only withdraw the application, the petition.
All right, so Raul, maybe what you can do is you can directly talk to your employer and tell them that you're not comfortable with the job or with the opportunity that you have. Maybe that's how it can be done, right? Right, Sonal?
Yep.
Yeah. Thank you so much, Raul, for your question. Let us know if you have another follow up. Meanwhile, Sonal, we are still getting too many questions from the viewers, which we are going to take, of course. But in a bit, let's quickly go for a break. And then after the break, we'll come back and take more questions from the viewers. And guys, I would like to tell you that if you want to connect with Attorney Sonal Sharma directly, if you want to get in touch with her regarding your case, you can give her a call at +1 646 360 5955. Oh, excuse me. I would like to repeat the number +1 646 360 5955. Her email is sonal@sharmalawassociates.com. Her website is www.sharmalawassociates.com. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my number, which is +1 732 707 9151. My email is rajni@hierarchypeople.com, and our website is www.hierarchypeople.com. So you can also visit our website. And remember, we sponsor H1B visas and other work visas based on job availability and regulations. And it's time to go for a short break. After the break, we'll take up more questions from you. So let's just go for a break. You guys stay tuned with Immigration and Jobs Talk Show. We'll be back shortly.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back, everyone. I'm Rajni Bharara. You're watching Immigration and Jobs Talk Show. And today I have with me none other than Attorney Sonal Sharma. And she's here to answer all your questions about H1B and L1 work visas. So anything that you would like to know about H1B or L1 work visas, please drop them in the comments. And well, Sonal, welcome back after the break. So let me quickly take another question from a viewer. Nitin is here, Nitin Kumar, and he says, can my wife work in USA while I am on H1B visa? Sonal, are you there? Can you hear me? I think maybe a bit of a technical problem. All right. Guys, I don't know, maybe Sonal can't hear me or maybe some technical issue, but I hope you guys can hear
I
me.
can hear. I can
Can you
hear
hear
you
me,
now.
Sonal? Okay,
Yeah,
great.
I can.
So Sonal, Nitin is here and he wants to know, can my wife work in USA while I am on H1B visa?
Oh, she can if you have an I-140 approved. She'll be eligible for H4 EAD. If you do not have an I-140 approved yet, then no, she cannot. Unless she goes on her own work visa or, other ways. But as a dependent, she can only work if you have an H4 I-140 approved, and she can get H4 EAD.
Okay. So Nitin, I hope you have got your answer. Thank you so much for your question. Let us know if you have another follow-up that you would like to know of. Let's quickly take another question. Okay, so I think we have taken a lot of them. So Yuri is also here, and Yuri says, my company wants to bring in a specialized IT consultant from India on an L1 visa to lead a critical project. The consultant has specialized knowledge and expertise that is not readily available in the US, and we need them to start work within the next 6 weeks. However, we have had issues with L1 visa applications being delayed or rejected in the past due to unclear or incomplete documentation. What are the specific requirements and potential hurdles we need to be aware of to ensure a successful application, avoid any delays or issues that could impact our project timeline?
It's very subjective and case specific, right? You are applying for an L1B visa for a very specific person. You need to meet the eligibility requirements. And the most common issue with L1B is that USCIS thinks that you are bringing people who do not really have a specialized knowledge, but are just general IT people, like a software developer who did not get picked up in lottery, and now you are trying to circumvent that and bring that person in the US on an L1B visa. So as long as you can show that they truly meet the requirements for L1B visa, yes, the scrutiny is very high and there are high denial rates for L1B visa, but that's only because, as he mentioned, the documentation is not proper. So you will have to make sure that you clearly explain what this person's specialized knowledge is, or if he is qualifying under advanced knowledge, then what is that advanced knowledge? And also, if the person is going to be placed at an end client location, that's also a red flag sometimes, because USCIS thinks that you are, bringing people labor for hire, which is not allowed under L1B, like a consultancy kind of situation where it's okay for you under H1B to place your employees on a third party location. It's not that straightforward and easy for under L1B. So you will have to clearly show why this person needs to be at the client location if they are going to be implementing stuff or doing projects at the client location. So there are multiple factors. This is a very generic question. All I can say is you have to make sure that the person meets the eligibility. You have the proper documentation to support what you're claiming in the petition. And as long as that's done, you should not have problem. But 6 weeks, to be honest, it's very tight from any perspective, because if you haven't yet filed the case, then by the time you file it, premium processing takes at least 3 weeks. And I'm assuming this is an L1B individual petition. But if it is a blanket petition where you can just directly send the person to the consulate to get an L1 visa, the documentation required for that is very little, as long as it is very solid documentation, which the consulate will look at it within 2 minutes and decide whether you qualified for an L1B or not. That's a separate story, and that's a different set of documentation and preparation. But for an L1B individual petition, you just need to make sure that you have proper documentation, you explain everything in detail, and just make sure that you have a legit reason for bringing that person in here.
Okay, okay. And Yuri, maybe if you want a proper detailed answer to your specific case, so what you can do is you can directly get in touch with Sonal. Her details are scrolling below. Her contact number, her mail ID, and her website is already there. You can get in touch with her. She'll be able to help you. You can give her more details about your case. As she said that it is a very subjective uh, question, right? So she will need more details to give like a proper answer, right? Right, Sonal?
Yeah.
So again, Shino is also here, and Shino says, my husband has an L1 visa and I have an L2 visa. We now want to obtain an L2 visa for my baby who was born after we got our visas done. Can someone please tell me how to go about it? We are little worried because my husband is traveling to the US in 3 days, and I cannot go with him right now because my 6-month-old doesn't have a visa. My question is, can the visa be processed in my husband's absence?
Yes, it can be.
Okay.
Husband doesn't. The kid will get the visa as a dependent, but he doesn't need to be here.
Okay, okay. All right. So it's a pretty simple and a straight answer. Yes, he can. And thank you so much, Shino, for your question. I hope that makes you happy. And let's take another question. Meenal Kumar. And Meenal says, this is my first year in the US, and I have to file tax return for 2023. Question: do I need to declare my non-USA bank accounts too, or file just normal tax return? Currently, I am on L1 visa.
Well, yes, you have to disclose your foreign tax bank accounts, but there is a limit. I think it's $10,000. If it is more than $10,000, don't rely on this information. I'm not a tax professional. You need to go talk to a CPA who will be able to help you file your taxes. But yes, you should be disclosing. But this is not H or L related question. So you need to go to a tax consultant or a CPA.
Right. So maybe Meenal, you can go to, like Sonal said, a CPA or a tax consultant. They will be a better answer, a better person to give you a proper answer to your question. But of course, you will have to disclose, like Sonal said. So Sakshi is also here, and Sakshi says, Canadian executive with a dismissed DUI record from 10 years ago qualify for an L1 visa to work in the US. What specific legal and procedural requirements must we meet for successful application?
Well, so if you're gonna go for a visa, then you will need to show the disposition, and obviously DUI is a big issue. Like it's not that just because it was 10 years old. Well, they are not going to refer you to a physician if it is more than 10 years, because any DUI related arrest or conviction in the last 5 years, they refer you to a panel physician to make sure that you don't have an alcohol problem. Or if you have two or more in the last 10 years, then they refer you to a panel physician to make sure you don't have a drug issue. But you will have to disclose that in the DS-260, DS-160 that there is an arrest, and most likely they would like to see all the dispositions and your history for the last 10 years, whether you have any alcohol related problem and what your uh, background looks like. It's not per se that it's not an inadmissibility issue, in the sense that in the non-immigrant visa context, it's not that you're not going to get the visa and you cannot come here on L1, but you will have to disclose it and convince them that you are not, it was just like if one-off issue that just happened and there is nothing funky going on in your record since then. But you will have to disclose it and overcome that presumption that you are not a risk to other people's safety.
Right, of course, of course. All right, so thank you so much, Sakshi, for your question. I hope you've got the answer. And let's quickly take, because we have, I think, just 9 minutes to go. So let's quickly take the pending questions from the viewers also. So Hannah is also here, and she says, I want to inquire about H1B cap-exempt visa. I completed my master's from University of San Francisco in December 2022. After that, I was working with a company for about a year. Mine was a non-STEM course. My company did not agree to sponsor my visa at the end of my OPT. So I don't have any options but to move back to India in February this year. Now I'm looking at options and want to move back. Do you and want to move back? Do you think H1B cap exempt visa is a good option?
100%. It's a very good option if you can find one. Yeah, of course. If you can find a job and the employer is cap exempt, then sure, go ahead.
Okay.
Fastest and easiest way to come on a work visa, because they don't have to wait for cap, file any time of the year, no lottery. So yeah, go for it if you can find a job.
Wow, go for it, Hannah. And I hope you get it. And thank you for your question. And CV Reddy is also here. And CV Reddy says, Indians come legally and illegal migrants enter with broken borders. They get a green card. What US expects? Okay, that's it. That's the question.
I don't know. I don't know what to say to this. This is not a question, and I am not here for a policy debate. So we can take up a question which I can actually answer.
So, to Mr. C.V. Reddy, I would like to say that we are soon going to have a political debate with, on our channel. So, just subscribe to our show and let us know. I mean, keep following us. And if you have any other questions like these, you can drop them on that show. We'll be glad to take them. This is going to be a political show discussing about all these issues. So, Mr. C.V. Reddy, you're more than welcome to join that session. It's going to be an interesting one. Let me promise you that. Okay, so Narayan Pandey is also here, and Narayan says, I have a question about visa stamping. My current H1B I-797 is valid till November 23rd, and my visa is stamped until then. I am in the process of applying for an extension. Once my extension is approved, I am planning to travel later this year. Now, can I apply for stamping before November 23rd, or should I wait till my existing visa has expired and then apply for renewal?
You can apply 90 days in advance.
Okay. Okay, I think that's it then.
Yeah, you're eligible to apply 90 days in advance of your visa expiry. So if he's going to go in, like, say, September, then he can definitely apply because it's within 90 days. You cannot apply more than 90 days in advance, but 90 days in advance, you can apply for renewal of the visa.
Okay, okay, all right. Thank you so much, Narayan, for your question, and thank you so much, Sonal. I think we have covered all the question in our today's show. So maybe thank you so much again for doing this show. It was amazing having you, and we tried to cover a lot of question, and we did get successful in covering all of those. So thank you again for coming and doing the show. It was again lovely having you, and we did the show after 2 weeks. So it's always a pleasure having you on the show, and I'm excited and I'm looking forward to another session, maybe hopefully next week if you're available.
Yeah, we'll definitely confirm. But yeah, thank you. Thanks for having me.
Thank you
Always
so
pleasure to
much.
be here.
Narayan is also here and says, thank you so much for answering my question. Thank you so much, Narayan, for your question. All right. So thank you so much, Sonal. Again, to our lovely viewers, if you want to get in touch with Sonal, so you can give her a call at her number +1 646 360 5955. I would like to repeat it, +1 646 360 5955. Her email is sonal@sharmalawassociates.com, and her website is sharmalawassociates.com. So you can
I think
write to her.
there are a couple of people who have just put
Okay,
questions.
people are
But
back.
can we have 5 minutes?
Okay, yes, we do. So let's quickly take Sean's question. So Sean is also here, and Sean says, "This is my first year in the US, and I have to file tax return."
Oh, I think we already took this question.
Okay,
There was a
Jitika is here, and Jitika says, "I am filing an H-1B petition for a software engineer position at third-party worksite. The beneficiary has bachelor's degree in computer science and 5 years of experience. However, the end client requires a master's degree for the role. How can I draft the petition to overcome this discrepancy and demonstrate that the beneficiary meets specialty occupation requirements, given the recent scrutiny on third-party placement?"
well, there is okay. I don't know who is writing this question. The require if your employment is with your employer, an employer is filing. So right now, the position that you're hired for decides what the requirements of the position are, and if the requirement for the position is bachelor's, then that's what you're gonna write in the letter. Now if you are gonna place an employee at an end client and the employer wants master's degree, then this person does not qualify for that role. You will have to place another consultant. If the employer says, if the client is ready, like, okay, I'm okay with somebody with bachelor's plus but extensive experience, then because bachelor's plus 5 is substantially equivalent to a master's degree under the PERM regulations. We are talking about H1B here. It has nothing to do with the equivalency of two requirements. You cannot match that like we do in the PERM if there are alternative requirements, but it is more towards whether the person you're applying for meets the requirement or the qualification, has the qualification to do the job which they are going to be placed. So if the end client is very rigid about they only need a master's degree, then this person does not qualify. You cannot make things up. But if they are okay that either the person has to have a master's degree or a bachelor's degree with 5 years of experience, then this person will qualify. But then you also have to take in mind that when you're calculating the prevailing wage, if the end client wants is okay with bachelor's plus 5 years of experience, you have to take into the consideration while calculating the prevailing wage. So it is much more strategy and how to calculate and prepare an H1B rather than a random question. I think your lawyer should be able to help you with this petition. The attorney should be able to help you. You should consult with them.
Okay, all right. Thank you so much for answering the question, Sonal, and thank you so much, Jitika, for your long question. I hope you have got the answer. Well, Sonal tried to give her the best answer, give you the best answer, and thank you for taking that up, Sonal and Jitika. If you have another follow up, let us know. And okay, Anjali Manuel is also here. Anjali says, "I have one more question." Okay, Anjali. And she says, I have my H1B and my husband is dependent on H4. My company is not willing to file I-140. He got I-140 approved for him. He's a nurse. I have my H1B and my husband is dependent on H4. My company is not willing to file I-140. He got approved. He got I-140 approved for him. He's a nurse. Okay. And then what option do we have?
For? Like, what is the question here? These are just facts. She's on H1B, husband is on H4. The husband wants to work. That's the question.
She says, my company is not willing to file I-140. He got I-140 approved. He's a nurse. I have my H1B and my husband is dependent on H4. My company is not willing to file I-140. He got approved for him. Okay, I am a bit confused.
So basically, I think she wants to know that how can he work? Well, nurses generally do not qualify for H1B. Of the states in the US do not have a bachelor's degree requirement for nurses unless it is a like specific nurse position, which is like emergency room nurse or cardiac arrest nurse or like something very specific which requires a bachelor's degree. And if the hospital is willing to give you that letter, then it might be possible. The H1B might be possible, and it might also be cap exempt. So that is the only way to go. Other than that, if he has an EB2 or EB3 approved as a nurse, but the dates are not going to be current, so he won't be able to work. Or you need to get your I-140 approved so that he can be on H4EAD. I don't see there is any other way for instantly start working. You can check O1 if they qualify, or go to school F1 and then get an OPT. Other than that, I don't see how you can work instantly. It's probably take time.
Okay, I think she's back and she says, what option we have for him to work again? I think I can,
Yeah. So
right?
yeah, I just explained all of that.
Right. So, Anjali, well, thank you so much for your question, and I hope you have got the answer. Let us know if you would like to know, about anything else. So, please drop your question, drop your follow up, and if you're satisfied with the answer, please let us know. And I think again we have completed all the questions, Sonal. So,
Okay.
and Anjali, if you would like to directly get in touch with Sonal Sharma, so what you can do is you can give her a call at +1646 360 5955. Her email is sonal@sharmalawAssociates.com. Her website is www.sharmalawAssociates.com. And yes, if you're looking for a project placement or visa sponsorship, you can reach out to me on my number, which is +1732 707 9151. My email is rajni@higherighttopeople.com and our website is www.higherighttopeople.com. Remember, we sponsor H1B visas and other work visas based on job availability and regulations. All right. So, Sonal, thank you so much again for a lovely episode. So, like I said, a few minutes back, I am looking forward to doing another episode, another interesting episode with you, like we did today. Maybe next week. Let us know your availability, and thank you so much again for taking out time and doing the show.
So, all right. Thanks. Have a good day. Bye-bye.
You too. And to our lovely audiences, thank you so much for your amazing questions. It was lovely, taking your questions and asking them from Sonal. I hope you enjoyed the show. It was quite informative and insightful. And but right now, I'll have to take your leave because the time, unfortunately, that's all the time we have. But you guys keep following our channel, keep subscribing to Immigration and Jobs Talk Show, and we are soon going to come up with another channel that is our Telugu channel for Immigration and Jobs Talk Show. We are going to have shows in Telugu language, immigration shows like we have in English language here, English and Hindi on this platform. So similarly, we are going to do it in Telugu language. So you stay tuned and keep subscribing and keep liking and keep sharing all of our videos. And thank you so much again for tuning in such huge numbers and for posting your questions. Thank you so much for that. And like I said, I'll have to take your leave for now, and we'll meet soon. But for now, bye and take care.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.